Hey folks, Elder Law Care attorney Patrick Kelleher coming to you from elderlawcare.com. Got a great question here today from one of our YouTube subscribers. Hey Patrick, how can we create a comprehensive smart estate plan that will benefit our grandchildren for their educational needs and educational purposes while maybe saving money from probate court, first-headed monster, but also from the second-headed monster, the tax man, right? Wouldn't that be wonderful? If you make the proper decisions, you could slay multiple metaphorical four-headed beasts here: probate court, tax man, bloodline protection, and maybe even Medicaid if done in conjunction with an irrevocable Medicaid trust. So let's talk about that. And first and foremost, my advice to the clients is you need to protect, because if you're looking to protect and preserve, what I talk about in my first book, protect, preserve, and pass on a meaningful legacy to the people you love the most without getting bit by the four-headed monster, which is essentially the government, you need to protect your hard-earned assets in your trust so they're not being wasted or being bit or being taken by the government in unnecessary probate, unnecessary taxes, et cetera, et cetera. So work with a qualified estate elder law attorney. Step one, create your trust or a treasure chest. Step two, get all your treasures in there to avoid probate, real estate and non-real estate. Step three, keep a good eye on it to manage and monitor that treasure chest to keep the dust and rust off it. That's the foundation of your plan, folks. It is not a do-it-yourself project. Work with a qualified estate elder law attorney to get that done. Foundation, like building a house right there. Then for this question right here, the nuances, how can we also strategize with educational plans? Well, the government has a thing called the 529 plan. It is an education-specific account that you can deposit money in there, and it has some wonderful tax benefits and tax advantages for you because the monies you put into that 529 plan will grow tax-deferred during your lifetime. And the withdrawals from that 529 plan will be tax-free so long as the withdrawals were utilized for qualified expenses. So you got to follow the rules of engagement, folks. So that's a wonderful benefit to use right there. Let's talk about some of the other benefits right there. You can deposit as much as $19,000 per year into that 529 plan in 2025 under the gift tax rules without the necessity of filing what they call a gift tax return, which is a 709 gift tax return if you go over that. So be mindful of that. However, Congress created a super cool thing called super funding. You can deposit as much as 5 years at one time. So a single individual, I did the math here, you can deposit $95,000 into a 529 plan for your grandchildren. Married couples, you can deposit $190,000, 5 years worth of gifts in 1 year, all at once. If you want to get a super amount, large amount of funds into that plan. And guess what, folks? The other nice tax benefit, second-headed monster. Not only is it going to grow tax-deferred and be tax-free when the withdrawals are made for a qualified expense, it is also the funds you put into the 529 plan are going to avoid or minimize your estate for the estate death tax. So if you live in a state like Massachusetts that has a state level estate tax, you need to be mindful. You need to get your estate under the $2 million threshold, or you're going to have an obligation to the taxing authority. 529 plan, if you deposit, say, roughly 190 grand in there, and if you had, say, a $2.1 million estate, that ought to be a prudent and wise strategy to get you beneath under that $2 million threshold. Therefore, you do not owe estate tax when you check out and go up to your cloud. Now, that is some smart estate planning right there. What is the caveat or the detriment? Detriment would be fourth-headed monster. Be mindful, because if you're depositing funds into the 529 plan, the good news, another benefit, you have control. You're the owner. You can name who the beneficiary is and so forth. But Medicaid is going to construe it as a gift that you put in money into this 529 plan for somebody else's benefit who's not your spouse for Medicaid purposes. So if either you or your spouse became completely incapacitated and were applying for Medicaid benefits to ask Medicaid to supplement and pay for your long-term care needs in a skilled nursing facility, Medicaid could look back 5 years at all your finances, and if you were giving money to a 529 plan, that could create a penalty period. So be mindful of that as well, folks. So you have to do what I refer to as a risk-benefit analysis right there, folks, okay? So that's all 529 planning in conjunction with the trust, which is the foundation of the plan. The supplemental planning is a 529 plan, not a do-it-yourself project. We're just talking about benefits and some detriments there. What else can you do? Things like Uniform Gift of Minors Act. Not a big fan of that because the beneficiary, once they attain the age of majority, usually 18, sometimes 21, they can take the funds and they don't have to use it. They do not have to use it for educational purposes. That's kind of an older law. I think the 529 plan is more nuanced and specific for the benefit of educational purposes, and it has some really nifty tax benefits there as well. Folks, I hope this video was helpful. Please click the subscribe button and the notification bell, and we will keep you updated on other important elder law subject matter. Thanks for being here today.